Good afternoon, everyone. Allison Schaberg here with Consolidated Planning Group. We are so happy that you have joined us today. I always like to start off with a few little housekeeping items. First things first, we are in webinar mode today, and that means that we can't see you or hear you, but we do know you're there, and our chat box is open for questions today. So we hope you'll put your questions in the chat box. If you put a question, if you registered and added your questions, we have those questions and there's no need to put those in the chat box. We're going to be getting to those as many as we can during the time that we have together today. We're going for an hour, so if you're planning your lunch or your day, everything that we do is recorded, and we also always share a copy of today's slides. So you guys will get an email. If when you registered, it said you were okay with communication, you will get an email with a copy of today's slides and a link to the recording. And if you check no for that, you won't get it. And sometimes those emails will go to your spam, so you'll want to check that out as well. Consolidated Planning Group, we are a holistic special needs financial planning firm, nationally certified Social Security advisors, members of the Special Needs Planning Academy, chartered special needs consultants. Our whole firm is nuanced in helping your family plan for the future of a loved one with a disability. We are different than what attorney Christina Lesher does. She is the paper and the legal documents, and we're the money. We often work closely together, but we don't do what Christina does. We don't create special needs trust or wills or help people file for guardianship or things like that. That's not what we do. We help people understand what the public benefits are, how and when to apply for those public benefits, how to have money in the right buckets to protect those benefits. We help answer questions like, how much money do I need to fund that special needs trust that was created by an attorney? How much money do I need to retire and stay retired and still have enough money to fund that special needs trust or pay for other special expenses like college for other kids or weddings or things like that? We help people put lifetime care plans and protection plans in place. We help work with families to figure out exactly how first we get the number of how much we need, but how do we fund that special needs trust and how can we keep our assets nimble for the 25 to 35 years that we're going to be spending in retirement? Because after all, we're paying for our own expenses and that of a loved one with a disability as well. So we want to clearly have access to those funds during our life. We do those future care cost estimates, small, medium, and large. A lot of families come to us and say, hey, we're still hopeful and optimistic. Little Johnny hasn't arrived yet. I mean, their brains aren't even fully formed until they're 26. And a lot of our kids with disabilities, it may be delayed. It may be delayed a little bit. But what we help people do is plan for the worst and hope for the best. And when the best happens, then that might mean that a person could retire earlier, or they may make some shifts in their plans that are more favorable than what they once thought. So we always say, whether you work with us or you work with Christina Lesher, work with a professional that is specifically nuanced with special needs and has an understanding of these public benefits. It's really, really important. Today, we're going to be talking about the Special Needs Trust, which is one place that we can have money that is not counted against a person for the Medicaid guidelines. And Christina is going to go deep and wide into that topic. There's a lot of questions on that. Surrounding that. And so she's going to kind of dive into those. But before we dive into all of that, what we want to do is we want to turn it over to Antoinette so she can talk to us about the Chosen Clinic, a little bit about who they are and how they work. And then we're going to turn everything over to Christina.
Thank you so much for that introduction, Allison. I really appreciate it. And hello to everyone on the call. My name is Antoinette Bowens-Whitaker. I am the social work care coordinator and office manager at the Chosen Clinic, where we are a primary medical home for children and young adults, 0 to 25 years old. We do have even though we're pediatrics, we have a transition piece where our patients typically transition into the adult side at age 16, where they're able to continue their care until age 25. And we work closely with the families to help transition them to a permanent adult care home after that. We do provide some regular case management, family support services that allow our parents to have some recreation activities, information sharing webinars such as this. And I thank you all for coming.
It always helps if I unmute. All right. Well, thank you, Antoinette. We love what you guys are doing, and thanks for partnering with us again. And it's always a pleasure to partner with Christina. Christina is a wealth of information. She's a little bit of a powerhouse. Sorry, don't be blushing on camera, but she's a big deal. She knows what she's doing, and I can say from our perspective, we take great pride in referring families to attorneys that we know they absolutely know what they're doing when it comes to these public benefits and the legal documents and having things structured properly. So it's always our pleasure to refer families to your firm, Christina. And so, having said
Well,
that, I know we got a lot to talk about today. So I'm going to
yeah.
turn everything over to you. Thanks for being here again.
Oh, thank you so much. And thank you, Antoine. I just made a note of all the wonderful things you do. Because I, like you on the call today, have a special needs person in my life. And so I'm always making notes and, oh, maybe I need to check this out. But for today, we're going to talk about special needs trusts and planning. So yeah, go to the next slide. One of the things I feel families really struggle with is, where do I begin? There's so much information out there. And by the way, I think Consolidated Planning Group has one of the best resources of information on their YouTube channel. I will watch videos there at my lunch break or in my car, just always trying to learn and grow my skill set. So please check that out. But other than Consolidated Planning's wonderful YouTube video channel, I would encourage you to think about starting with the following: planning for incapacity and illness. Oh, okay. Can you hear me, Allison? Oh, okay. Okay. Gotcha. Okay. We want to plan for incapacity and illness of a parent or a caregiver. That is hard to think about. I'm struggling with that in my own family. Planning for wealth transfer, and that's something that Allison can help you do. I build the buckets, and Allison will tell you how much you need in them. And then we're going to also need to think about supplemental or special needs trust. Most of you on the call already know that these public benefit programs that support our families and loved ones have a very low asset cap. In fact, for an individual who is going to be on a public benefit such as Medicaid and SSI, their assets that are countable have to be less than $2,000. So there's lots of assets that are not countable. You may want to think about an ABLE account or a home or a vehicle. But if we're leaving, say, a life insurance policy or a retirement account to a child or a family member with a disability, that's why we want to have a supplemental needs trust. What does it do? It can pay for housing, clothing, support costs, pay for things that Medicaid doesn't, pay for educational expenses, life-enhancing expenses, and any of the assets that are in that trust are not going to be considered countable when determining financial eligibility for your child. There are a little list down there of exempt and countable assets. Take a look at that. Yeah. So now we're going to talk about avoiding incapacity and illness. Yeah. So go to slide. Yeah. There you go. So this is a big topic in my practice, especially for families whose children are approaching age 18. And then Allison, I know you're going to have some comments here. You always have some really good nuggets for families to take home. But I would first introduce the 18-year-old question by letting you know, once your child turns 18, you are no longer what we call their natural guardian. So I have an 18-year-old son. He's about to head off to college, and I'm going to do powers of attorney for him before I send him to Colorado. because even though he's on my payroll, I do not have legal authority to make financial or medical decisions for him anymore. So for any child, whether they have a disability or not, when they turn 18, we're going to have some decisions to do. So when your child turns 18, you may be thinking, I have to run right out and get guardianship. If I don't, something terrible is going to happen. I would advise you to take a beat, go speak to an attorney, because everybody's situation is going to be different. You may have had a friend that had a guardianship and it worked well. You may have had a friend who didn't have a guardianship and it caused a lot of problems. But your child and your child's needs are going to drive that decision. So you can avoid guardianship with what we call a durable or a financial power of attorney. I have a few notes there that if you have a power of attorney, you want to allow the agent to make payments for your special needs family members, and you're going to want to send it to the bank to get it approved. Medical power of attorney for decision making, HIPAA release for medical information. It's not typically a decision-making document, it's a release of information, and directive to physicians, which says what you would like to have done in case you're in a terminal or an irreversible condition. So, we're talking about our kids, but we also need to talk about ourselves and plan for ourselves. So if you're sitting out there and you're married or you're not married and you're over the age of 18 and you do not have powers of attorney, please consider that. The other option for your child, and we're going to, talk about guardianship here just a little bit, is what we call a supported decision making. It allows individuals to make their own decisions. And it also allows them to have a person to help in a supporting manner, but that supporter cannot make a decision for the person with a disability. And Allison, I see you're back on screen. So yeah, what good nuggets do you have to give to the families today?
Couple of things on the power of attorney, healthcare power of attorney, and HIPAA release. So yes, and you and I talk about this all the time, but such a great idea for your adult kids age 18 and over to have these documents in place. Super important to have it for yourself, which you mentioned. But I think it's also important to have intentional conversations with aging family members in your life that may not have these documents in place, and not wait for the crisis to happen, a stroke or heart attack or some incapacitating illness. And we find out that these things are not in place. We've seen where people have had massive middle brain strokes, but they didn't die, but they were completely incapacitated without these documents in place. And there's not a whole lot a person can do without having those in place. And then the other thing I wanted you to talk about, the healthcare power of attorney. I think that there are some misnomers out there on that healthcare power of attorney, that if my kid signs the healthcare power of attorney, that just gives me rights to make all the medical decisions. But
Yeah,
doesn't that
yeah,
person have to actually be incapacitated?
that's
Um,
right. Yeah, yeah. So when we look at a legal document, we need to know what it does, and you've identified that, and we need to know when is it effective. So you can have a child, to my son Luke, who's 18, I will have a medical power of attorney for him, but that doesn't mean I get to make decisions for him right now. He has to be incapacitated as certified by one doctor. Some documents will say two doctors. Yeah, and then the financial power of attorney, I typically draft it so it's effective immediately and easier to use. So, but keep in mind, you can have the HIPAA release, which would be effective immediately. That's not a decision-making document, but it is access to information. So if your child is in an accident, you will be able to communicate with the doctors. But you're right, it is not a decision-making document if your child has capacity.
Where these documents, and I've seen this be an issue in the past, where these documents weren't in place for these kids that were off at school, and the kid had a mental health issue, where maybe they were taken somewhere
Mhm.
to get help. And if these documents aren't in place legally, they're not being difficult. It's the law. They can't even tell you where they took your kid. And I've had families before that were mortified by that. So it was like a needle in a haystack trying to figure out
Mm-hmm.
where the kid had been
Mm-hmm.
taken. And
Mm-hmm.
so that's why this is so, so important. The other thing, and I know that we're talking about trust today, but on the guardianship as it relates to Texas, we talk about this a lot. The least restrictive, most appropriate for the ward is the word that they use. And I know that a lot of families feel overwhelmed with this decision, or they feel ill-equipped to make that decision, or they feel strongly that they don't want to take their child's rights away, or things like that. And I always just like to encourage family to go sit down with a legal professional. Their job is to talk through this with you and to help you come to what is the least restrictive, most appropriate. So when you set that appointment with an attorney, you don't have to know everything or know what you need. They're going to be talking through that, talking to you, talking to your loved one with a disability, and together coming up with that. So I just want to encourage people not to
Yeah.
feel afraid about that, because
Yeah.
they've never done it before and it feels a little scary, you know?
Yeah, and yeah, you don't have to know all the answers. That's a conversation to have with legal counsel. The other thing I would encourage you is that don't feel pressured. Oh, I have to have it done on my 18th birthday, or we can't. We can do it at any time. After a person turns the age 18. Sometimes what we'll do is we'll think, maybe we'll try to do a supportive decision-making document coupled with powers of attorney. Maybe that will be enough. If it's not, we can always go to guardianship later. When we go to guardianship, I have to present before the court testimony that there was no other way that we could have avoided the guardianship. And we have to discuss these things with our clients anyway. So it's a discussion you have to have, even if you're going to go through guardianship. And we have that discussion in my office, even if it's very clear that this child needs a guardian to make decisions, we still have that conversation with the client, because I would never want to have a situation where maybe a child actually has capacity, but maybe they communicate a different way than I'm familiar with. And I think that person's incapacitated and they're actually not.
So, okay, last thing before we move on from this, Christina, I just want you to address the issue of people having their loved one that does not have capacity,
Yeah.
signing powers of attorney and other documents that they do not have capacity to understand what they're signing. So I want you to talk about the other side of it real quick before we move on.
So like if somebody signs something and they don't know what they're signing, or they don't have capacity, then
Correct.
those documents are usually voided or voidable. You may have to go through guardianship court anyway. We see that a lot with older clients where maybe mom has had the oldest daughter as power of attorney forever. Another sibling sweeps in and gets mom to sign new documents. I've had actually a case where mom's daughter's boyfriend had mom sign documents like in the Kroger parking lot. And then we ended up having to go to guard to show that mom did not have capacity on the day that she signed those documents. And those are very, very expensive. So, Allison, one of the things I like that you suggest to families is clear communication. I think if families would talk about some of these things ahead of time, and it would help, maybe the family dynamics will drive those types of situations.
Thank you for
One
clarifying
person
that.
said in the chat box, could you do both a HIPAA release and power of attorney yourself, or do you need an attorney for that?
Well, I want you to have a medical power of attorney and a HIPAA release together. So maybe answer that question first. You do not have to have a lawyer. The problem that I see with people not at least getting the documents reviewed by an attorney is that they will complete them incorrectly. So there's a reason why we go to law school, to make sure everything's filled out correctly. But I would definitely at least get it reviewed by a legal counsel for a consult. If you can't afford an attorney, the Houston Lawyer Referral Service and the Houston Volunteer Lawyer Program will be able to assist you.
I always just like to tell people, if they're tuning in from anywhere and they're in a position where they can't afford an attorney, if you go to Google and you type legal aid and then put in your city or your county, the legal aid offices in your area will pull up and you can check those out as well. So I just want you to expand just a little bit further about the alternatives
Sure.
to guardianship. We talked about the supported decision making agreement. And do you feel like the supported decision making agreement goes nicely alongside the power of attorney, healthcare power of attorney, and HIPAA release?
Yeah, I think in some cases it does, especially where maybe there's an adult living with a disability who feels that maybe they want somebody to help them, but they are concerned about people taking away their independence and their ability and their autonomy. So I've had conversations with adults that are living with a disability that maybe we have these documents drafted and maybe we put them in a place where people can access them in case of an emergency. But maybe you want your mom to be able to go with you to the bank and support you and be able to communicate to the bank or be able to communicate with the doctor, but not make a decision. It's a very nuanced situation, but my hope would be that if you have a supportive decision-making agreement, that you also have powers of attorney as well, in case you are incapacitated.
Also, and then I want to go to Antoinette before we move on. Christina, I've seen you draft an educational power of attorney that I think is beautiful.
Thank
I
you.
love power of attorney. And that is really good for families who's going to have a child that may stay in the school
Yeah,
system post age 18 up
yeah,
to age 22. So I know
yeah.
that's not on the sheet, but I'm a huge fan of that document that you've got there. So anyway.
Yeah, and you have it, and anybody who wants to access that document can ask Allison. This is not recognized in statute. It was drafted um years ago. I had situations where clients were going to our meetings and their children were turning 18 and the school was really pressuring them to get guardianship. So we use this as almost like an interim document. Of course, the person has to understand what they're signing. But what it does is it allows the parents to come in and make educational decisions for them. Yeah, and Cindy, yeah, you are welcome. Just shoot Allison or her team an email. You are welcome to spread this document around. It's not proprietary, add to it. So yes, thank you for
I think
mentioning that.
I'll just have Meredith send that educational power of attorney out with today's slides and the link to the recording. Antoinette, did you want to mention anything here or kind of big
Yeah.
takeaways?
Yes. So what we try to do at the Chosen Clinic, as you ladies stated, make sure that we clarify with parents the difference between the medical POA, the HIPAA
Yeah.
release, the supportive decision making. We also have for our patients an internal medical legal partnership that we work with to assist families with reviewing of these documents and assistance with filing for guardianship if they need to in the court. And I really appreciate the point that you ladies made in regards to the difference, because we'll have some parents who, for instance, at 18, they get locked out of the electronic
Yes.
medical records, and it's a nightmare. They can't follow, they can't track. And sometimes we have parents who will show up with a medical POA, and it's a child that has had a TBI or a cognitive issue since birth. And so
Mm.
it's really, really good, I think, for them to know how it's used, what it can be used for, and how it can be an issue later. But I think it's also even more important to know that having um, more than one of the documents can also be very beneficial, especially if you're in the process of obtaining guardianship. So I definitely appreciate that information. I think it's very helpful.
Yeah, and the other thing that I just want everyone to know about it, because there's one of the fears my clients have is between their 18th birthday and the day that they're appointed guardian, there's going to be a gap. So, but just know under the health and safety code, if your child's hospitalized, it does allow you to make decisions for your child if they're in the hospital. It's not going to be able to get you into my chart typically, but it will get you to do other things. So,
I've seen some
yeah,
of the MyChart access go away as early as 16, I think I've seen.
yeah,
I
yeah.
think it depends on the institution or whatever, but I actually have seen that before. Okay, so we are going to keep on moving and we're going to dive right into that third party special needs trust. That was a
Yeah,
great discussion. And the thing
yeah,
is anytime we have one of these webinars, every little rabbit hole that we go down, there could be a whole 1 hour webinar
yeah,
for it. And there usually is.
yeah.
That'll be out there on that YouTube channel. So if you need more about the steps and like
Hmm.
how the guardianship works, go out and listen to the guardianship webinars that we have on that YouTube channel, and it'll talk about the whole process and what you can expect and when to start, about how much it costs, all that kind of stuff. Okay.
So let's talk about third-party supplemental needs trust. And it's just such a weird title. And I think clients and families just struggle with what is third party? A third-party trust is one that is established with money that does not belong to your child. So the rules are a little bit more relaxed. Um, Anybody can serve as the person who establishes the trust. That's called the grantor. It can be in a will or in a revocable trust. I personally like either a standalone, meaning it's created during your lifetime, or a supplemental needs trust that's in a revocable trust because it's funded faster. Maybe you have a life insurance that Allison helps you with. You say 60% goes to my child with with the special needs into a supplemental needs trust. That trust receives the assets and they don't have to wait for probate to go through. Probate in Texas has become much more efficient. But if you have a disabled child that relies on you for food, clothing, shelter, support, they are not going to want to wait 4 to 6 months for that probate process to begin. But a will with a supplemental needs trust is better than nothing, and that's perfectly okay. Maybe you make other arrangements, such as you have an account with a trusted family member that provides for 3 to 4 months of money for your child, and you trust that that person will do the right thing. But I personally like to have it already set up. There's no requirement that it has to be set up before your child turns 65. And there's no payback to the state of Texas. That's a big benefit. And Allison and I are going to talk about our favorite subject next, which is beneficiary designations. So
I
Allison,
wanted
as
to
the
pause on that third party special
okay.
needs trust because I
Mhm.
have to say I agree 1,000% that I'm a fan of it being already established as opposed to living inside of the will and being established
Yes.
after your death. But one clear thing I want to make crystal clear is that if you have it inside of your will and it will be set up upon your death, if grandma and grandpa die and want to leave money to your special needs child, the special needs trust is not set up. So if your loved one with a disability stands to inherit money from other family members, that is a pretty clear sign that you should have that special needs trust set up and not have it in the confines of your will.
Yeah, absolutely. If you have a third party supplemental needs trust, and by the way, visually, I think of a supplemental needs trust like my coffee cup. It's like a bucket, it's like an entity, it's something that money can pour into. You know, I grew up the daughter of school teachers, so I didn't know what a trust was. But a trust is a legal document that can receive assets that are titled in the name of the trust that do not have to go back to the state. If your child passes, you can leave other children as what we call contingent beneficiaries. And there's all kinds of good things that we can do and interesting things we can do. There was one question I wanted to weave in to our conversation. And it says how to find a trustee who understands the importance of therapies. If not immersed in this life, they may not understand. So with third party trust, we frequently do something that's called a letter of intent, which is all your hopes and wishes that you can prepare outside of the trust so it can be flexible. And if you're wanting to make sure that this trustee really understands that therapy is something that is going to benefit your child, I would definitely want to include that in the letter of intent. And I know that Consolidated Planning has a wonderful video on letters of intent because I've watched it.
It comes to these beneficiaries. I mean, you and I, we beat this and beat this to death. And I feel like I'm like a broken record because I think I say it in almost every webinar that we have about beneficiaries. Beneficiaries are so super, super important. And there is a misnomer out there that if I work with an attorney and I set up my wills and trust and I set everything up, that it's done. But the thing is yeah, those legal documents are done, but a beneficiary on the life insurance or the investment account trumps everything. So whatever the beneficiary designation is who is getting the money. It doesn't matter what your legal documents say, it's who the beneficiary is on those accounts. So if you're taking notes, I think it's really important to check your old accounts, old beneficiaries, old life insurance contracts, old investment accounts, 401ks. One of the ones that is definitely forgotten many times is those old pension plans. I know a lot of people, pension plans are a thing of the past, but a lot of people, especially with the oil and gas companies, do have pensions, and checking those beneficiaries on that is really important. And the main thing we want to make sure is that we don't name your loved one with a disability directly as a beneficiary on anything that you have. Instead, you want to name that third party special needs trust.
Yes.
But before we get there,
Yes.
let's talk about the people that say, you know what? I did this perfectly. I just disinherited my kid and I'm giving all the money to the other two
Oh,
kids and they're going to take care
yeah.
of
I just
little
had a physical
Johnny.
response. Like my chest literally just tightened because
Yes.
we see, oh, yes, when it maybe your daughter says, oh, I can take care of my brother Johnny, but maybe she gets divorced and then that money gets wrapped up into the divorce. Maybe there's a lawsuit. Maybe she passes away. It does not provide for a succession plan. I am, and this is probably my personal life speaking through today, is I do not like seeing people with disabilities being disinherited from plans because of their disabilities. There's other ways to do it.
Agree so much. And the thing is we call it life. Life happens. Like you said, people die, people become disabled, people get sued, people get sick, other things happen. And so having it set up properly to that third party special needs trust is going to ensure that your wishes are going to be fulfilled and that your loved one's needs are going to be met and that there's going to be money there to handle that appropriately. So if you've done that, there's no shame. Okay. First of all, if you're thinking you're sitting here and you're saying, oh my gosh, my beneficiaries are a mess. And I would be shocked if at least half of you on here don't have your special needs loved one named as with a disability named as the beneficiary. Because what a lot of people do is if they're married, they name their spouse as the beneficiary, and then and then if you die and the spouse is already dead and gone, then they say, well, I'm going to divide it equally amongst my children. And that is a very common way that beneficiaries are set up. And what we're saying today is it's wrong. But if you have done it that way, it is an easy fix. It is a change of beneficiary form for whichever carrier you've got the contract with. And it is also, well, obviously you have to have a third party special needs trust, but those change of beneficiary forms are free. It's free to get this corrected and updated. And we just want to encourage
Mhm.
you to,
Yeah,
put that on the list and look at it, but don't beat yourself up and it can totally be
no.
fixed.
In fact, I want you to think of it more like a to-do item that has an anniversary date. I actually need to update my beneficiary designations as well. I love an Excel spreadsheet. So I have all my Excel spreadsheets, all my Excel spreadsheet of my assets. I don't have a ton of them, but I have a list of them. And then I have a list of who's going to be in charge of the assets when I become incapacitated. And then a list of where the assets go at my death. So I have a special needs nephew, which means that my two boys are not going to be sharing every asset 50-50. There's one asset that I'm going to leave primarily to my son, my son. He feels like my son, but my nephew that has a special need, and that is my retirement account. And I thought we could take a little rabbit hole and talk about retirement accounts with third-party supplemental needs trusts. Allison, do you mind doing that?
No, I think that this is a good time for that. We actually had a question about that on I think that I saw about funding a special needs trust with retirement accounts or other assets. So you want to chat about that a little bit?
Yeah.
So, I mean, when it comes to, I would say that what we see with family is a lot of times their greatest assets are 401ks or IRAs or pension plans, right? The assets with the highest balance account balances. So it's not unheard of or unreasonable for it to be funded with IRA money. Okay, so that is something that does happen, but a lot of times what people don't know is that there are rules and guidelines to be able to get the lifetime stretch. So there is a such thing as, so there are requirements, like when you inherit an IRA that they require that you have to take this money out within 10 years. But there is some law that has a lifetime stretch that allows the person to stretch that money out over their lifetime as opposed to all at once or within a 10-year period. But there is proof that needs to be sent that the person is disabled, and that proof has to be sent the following October of the person's death that left the asset. So I've actually seen, Christina, some people that missed out on the lifetime stretch by not hitting those guidelines in that time frame. I don't know if you've run into that, but
Yeah.
it is important to look at that.
Yeah, yeah. Yeah, so one of the things I encourage families to do is work with someone like you and myself, and we even need to bring in a CPA sometimes. And we figure out which asset may go to the child without a disability, which asset may go to the child with a disability. So among other decisions, that's just something to talk about. And by the way, that's the reason why you review your accounts and your beneficiary designations on an annual basis. I typically like to pick a holiday. 4th of July is coming up, so I've got a couple of days off. In between the fireworks and the barbecue, I'm going to bring out the spreadsheets because woohoo, why not? Why not? But
Right.
you may want to pick an anniversary date and go over some of these things, including the trustee selection. A lot of my clients come in and they're like, oh, um, I want to have the sibling as a trustee. In some families that works. In some families it doesn't work, or it may work if the siblings have an out. Maybe they can serve as trustee, but then they can slide into the role as trust protector and appoint a corporate fiduciary at the time that they don't want to serve anymore. This is what I've done for my own family. I've got conversations with my two kids who are 18 and 16 since they were little. As part of our bedtime story, we talked about how we were going to help our cousin. And we talk about, listen, who wants to do the money? Who wants to do the healthcare? I've got one kiddo that wants to do money, one kiddo that wants to do healthcare. Those are kind of the foundational conversations you can start having with younger kids about being the trustee. It may not be appropriate for your child to be a trustee at all, maybe a third party, especially if we've got situations where there's already emotional issues between the siblings, which is common and normal and okay. But we just want to make sure that whoever we appoint as a trustee is set up to do the best job. Um,
Christina, I had another
sure.
thought that we need to go back to on that beneficiary thing that I think is important and often missed. There are people that are getting pensions, monthly pensions. It could be a military pension or something through the VA that might continue for their disabled child. There was, for anybody for that military pension, there was a law change in 2015 under the National Defense Act. It's the Howard P. Buck McKeon Act, where that military pension can be
Yes,
redirected to a first party special
that's
needs
right.
trust. But this monthly income matters, and I want you to talk about that. If there is pension monthly income that would be coming
Y-
in as a result of the
Yes.
death of a parent.
Yeah, so if you have a military situation that you would those pensions have to go to a first party supplemental needs trust. If the financial institution will allow you to appoint a third party trust as or the trustee of a third party trust, but honestly, sometimes we have when that parent dies, we have to get a court order to enforce that distribution. Usually, if there's an estate or if it's through a guardianship. And that's at the requirement at the financial institution.
So the bottom line on this third party special needs trust, we've talked about that this is the right way to leave money for the benefit of an individual with a disability to help them maintain their eligibility for state and federally funded programs, SSI, Medicaid waivers, etc. Um, so, and this is a place that they can have the money that's not going to count against them. And I
Right.
want us to talk about, so let's say we didn't know that grandma and grandpa made your child, little Johnny, named him directly as the beneficiary on their life insurance contract.
Mm-hmm.
So now we've got little Johnny getting $200,000. Um,
Mm-hmm.
tell parents how that can be fixed in the event. It's better to have the conversations on the front end so it doesn't happen to
Yes.
begin with, but it's
Yes.
not all is lost and everything's out the window. It could be
Yeah.
fixed if that happened, correct?
Yeah. Yeah. If the person is under 65, hopefully that's how their age when this happens. And let's go down to the first party supplemental needs trust.
Okay.
Yeah, I think it's just like 2 or 3 slides. Yeah. Where did it? Hold on.
There we are.
There we are. It took a minute to get there. But okay, so we're talking about first party trust. Okay, so remember when we talked about third party trust, I said third party trust, those are the trusts that are funded with money that belongs to grandma, grandpa, aunt, uncle, mom, dad, not your kiddo. Okay, so what happens if your kiddo is in this situation? What was the scenario? Was it 200,000? So they inherit 200,000, maybe it's payable from like a life insurance policy or a bank account, and the families come in and they're just like disheveled and upset, and they just think that the world has ended. It's okay because we have this trust document that's called a first party supplemental needs trust. It's just like my coffee cup. It's a legal entity. It's a document where these assets can be transferred that would have otherwise caused a period of ineligibility, but we have to draft these documents very carefully. The person who establishes the trust has to be a special person, meaning it has to either be the parent or grandparent of the individual. It could be a court order or by the beneficiary, meaning your kiddo could actually establish their own first party trust. And the power of attorney of a beneficiary can also establish the first party trust. In Texas, if we fund these over age 65, that's a transfer penalty or a loss of eligibility. And these first party trusts, unlike the third party trusts, have a repayment back to the state or states that they lived in and received Medicaid benefits. Sometimes we put child support into these trusts to qualify for SSI for divorced parents. And they can also be coordinated with an ABLE account. Now, I'm going to hand this over to Allison in just a second because she is the guru on the ABLE accounts. But I want you to know that each state is so different in their interpretation of Medicaid and rules and laws, but especially on supplemental needs trusts that are first party, because Medicaid looks at these trusts as a loan to the Medicaid beneficiary. They think, oh, well, you would have been ineligible, but we're going to let you keep the money in a trust with these certain rules. But every state is going to have different rules. And I bring this up because I've just had an issue with a beneficiary who came from Colorado, and it's messy. So if you're thinking about moving states, especially if you have a child, for example, that maybe had a birth injury and there's a personal injury settlement and you've got a court created trust and you want to move out of Texas, be sure before you move to that other state that you have local counsel at that new state review the trust for any changes.
And that's also true for guardianship. Guardianship is county
Yes.
specific
Yeah.
here. And if you're
Yes.
moving out of state, the guardianship's got to move
Yes.
too. I would,
That's right.
yeah, I think all of these factors kind of, I mean, it definitely does feel like a lot. The best idea is if we can help it not to have a first party special needs trust, not an oops trust where somebody accidentally left our loved one money. I mean, if they got a settlement, it's first party money. If it's their money, like we had somebody a couple of weeks ago that had Exxon shares in the kid's name, right? And it was
That's
the kid's
correct.
money. So it had to go to, and it was more than what we could get into an ABLE account. So it had to go into that first party
Right.
special needs trust. So, one question that I get all the time, we get the best questions. I love the write-in questions, but one question I get all the time, Christina, is so if I go get a if I have a first party special needs trust from another state that doesn't have a Medicaid payback, but then I'm getting Medicaid in Texas later, like, so maybe the trust was drafted previously in another
Okay.
state. There's no Medicaid payback in that particular state, but now they're residents in a state that does have a Medicaid
Yeah.
payback. How does that
Yeah.
work?
So the number one, you always have to notify Medicaid and Social Security if you have a trust. Number two, when that beneficiary dies, you need to reach out to that state's Medicaid payback. I would even go back to the state that says that they didn't, or you thought that they didn't have a payback, just to make sure that something hasn't changed. But what happens is that if there's not enough money, each state would get what we call a pro rata portion. So if Texas had the most expenses, they would get the bulk of the repayment. And then like if Idaho had the rest, then Idaho would get the least amount. But remember, when the payback happens, the payback is not at it's not at a fair market value rate. It's what we call the Medicaid negotiated rate. So we see a lot of this, especially with my clients who are on nursing homes and may have had like early dementia. We've put money into a first party supplemental needs trust for them. They pass away in the nursing home. The families are often surprised that there's monies left over, but I have to remind them, listen, you're not paying the nursing home at the fair market value rate. You're paying at the lower Medicaid negotiated rate.
And I just want to take that one step further on the ABLE accounts. People say, should I have a special needs trust or an ABLE account? My answer is always both because they
Yes,
work beautifully together.
yes.
An ABLE account is organized under the tax code 529A for ABLE. It was enacted in 2014, and it's a place that we can have money. It grows tax-free distributions. If it could be construed as achieving a better life for an individual with a disability, we can pay
Mm-hmm.
for it out of an ABLE account. And an
Mm-hmm.
ABLE account can pay for food and shelter without a
Yes,
one-third reduction to
yes,
SSI. I so
yes.
often hear people say, I heard you can't pay for food and shelter out of a special needs trust, and that is simply
Nope,
not true. That
not
is
true.
wrong. You
Not true.
absolutely can, but if the individual is getting SSI, then
Mm-hmm.
that shelter cost would reduce the SSI. But most of the time in that example, the parents, the kid isn't getting SSI anymore. They're getting Social Security or childhood disability benefits
Yeah,
under a parent's record. And
yeah,
that's a whole nother discussion and ballgame.
yeah,
But we
yeah,
just want to be clear that if you've heard that you can't pay for food and shelter out of a special needs trust, you can, but it depends on what level of public benefits they're getting on whether or not it would reduce those public benefits. So, and then the last thing on the ABLE accounts, the next question that people give, all the time, and it's a really great question. I heard I can get an ABLE account from any state. That's true. You could get an ABLE account from other states. And so what I'm wondering is, could I go to another state that doesn't have a Medicaid payback on their ABLE accounts and avoid the Medicaid payback? And the answer is
oh,
no. It's based
no,
off of the state in which
yeah,
you live. So if you live in Texas and Texas happens to have a Medicaid payback, even if you went to another state that didn't have a Medicaid payback, that Medicaid payback would be applicable to the ABLE account. So I just wanted to mention that. So where do you want me to go on slides? Backwards or forwards?
yeah, I just wanted to say one more thing on the Able account. Let's not forget the point of the Able account is for your kiddo, their name can be on the Able account and they can have more than $2,000. I think that is such a great step towards people being able to be more independent and autonomous. So families are always worried, oh my gosh, the Social Security account, it's getting down. It's building up because the parents are providing a lot of support, our kids working. Use the ABLE account in these situations, and it's a great opportunity for kids or adults who are maybe working to learn money management skills. I'm all for pushing the envelope to make people as independent as they possibly can be. Um, and I also too think they're human beings and they have a right to money. So that's just,
Right.
yeah, yeah. So I'm gonna get off my soapbox for just a second and let me go
I
back
wanted to make
here.
a comment about the ABLE account. I typically
Yeah.
try to tell our parents also, for families who, maybe you don't have a settlement and a lot of money, but you have more than you're allowed to have with SSI. I think the ABLE account is a good option, especially because it's easily accessible and it does
Yes.
allow for some risk, responsibility, some money management learning and things like that from your loved one. So I think it's a great option when there's not, massive amounts of money and when you need to easily access the money for simple things.
Yeah.
Just basic things that you would love to do with or for your young adult or your child who has special needs. I think it's a great option for those things.
Yeah, and
That's
yeah,
right.
I do too. I'm all for pushing independence and autonomy as much as we possibly can.
We did
Okay,
have
so
something in the chat box. Can a
oh
first
yeah,
party special needs trust be created after an asset is inherited by the special needs child? And that's an absolute yes, but they do need a court
yes.
order to redirect those assets to the first party special needs trust. Is that correct? They need
Yeah,
something.
kind of, well, it depends. So if the child has capacity and they're not under guardianship, we don't need to go to court. So a first party trust can be created because not every person, of course, with a disability also has an intellectual or a cognitive disability. The other thing I want to tell you is, let's say, and I don't have a slide on this. I'm gonna make another note for myself. I've been making notes on things I want to change, Allison, the whole time. Um, if your child is a beneficiary of an estate that is being probated in Texas through a will. So let's say I have a will, I'm going to leave my nephew money through the will, and I don't put it in a supplemental needs trust. Oops. Back in the old days, we would have had to put it into a first party trust. Now we have something that's called will reformation. This does, Allison is correct in that it requires a court order. And then the court can go back in time and stick a supplemental needs trust into the will, and it's a third party supplemental needs trust. So there are some options. It did, like anything in life, it depends on the fact situation, what we do to clean up. Let's talk. Can we go back to, it says common concerns about using SNTs? I just want, I just want to make sure that we underscore about not giving family members money to hold. And if you're going home and your spouse or family member says, why not just give the money to our daughter? That's the slide. Mismanagement is a big issue with assets. And let's go up to dividing the estate. I think it's just the slide above. Yeah, one more. Oops, sorry. It's my slide 17. There we go. So this is another topic I'd like to hit on. Sometimes what is fair is not what is equal. So if you have 3 kids, maybe one child is living with a disability and they're not going to be able to have the type of income and work that your other children or other beneficiaries would. Let's think about what is going to be needed. And that's when you're going to want to swing back to Allison to figure out how much money do we want to fund in this trust. Maybe life insurance is a way for us to even things out and give the child with a disability a little bit more. I do believe that all children should get something at the death of the parent. And I do think that in order for family to continue on the work and continue on with helping that person with a disability, managing expectations ahead of time is super, super helpful. And Allison, I'd love to see what you think about that as well.
Yes. I think what I tell people, there's no right or wrong answer. We have some families that want to be super fair and everybody gets everything equal, and we just want to be fair. And then we have other families that are intentionally not fair because they say, look, we pay for college for these other kids and they're in great jobs and they're making a ton of money and they can provide for their families, and this child's never going to be able to do that. And so we have an unequal distribution for that reason. And then we encourage an unequal distribution if there's not enough money. So if there's enough
Yes.
money for them to retire and stay retired for 25 to 35 years and still leave equal distributions to all of their children, and it's enough for the a special needs child, then we're in favor of that. But if there's not going to be enough money at the end of their life, then we would favor the individual or individuals with a disability over the neurotypical kids. And what I would say is this is a very personal decision,
Yeah,
and I don't care who you talk to. There's not a right or wrong answer.
exactly.
It's what is right for you and your specific situation. And furthermore, I will say this is why I always encourage our families, Christina, to update their legal documents or at least get a lawyer to look at them every 3 to 5 years. Laws change, your vision changes on how you see
Yes.
things. When I updated my documents last year, I was laughing at some of the provisions that were in there. They were appropriate at the time, and it was only like 4 years earlier. And they were not appropriate at all at the time when I was looking at it. So I think it's really, really important to talk about that. And then also those intentional conversations with the other kids so they understand. And then there's not this big animosity or we don't
Yeah.
appreciate our sibling with a disability because of this. Like
Yeah.
we feel
Yeah.
jaded.
Yeah. I feel too that the children, if they're being asked to be a trustee, should get something from their parents. Um,
It's a big
I,
job.
it's a big job. We can write compensation into the trust document, but I do think that that's helpful. There was a question that said, can a trustee be a family member overseas? Absolutely. Um, I I always say I want the 3 T's for a trustee: time, talent, and trustworthiness. Those are the people who need to serve. Okay. Did you want to take a question or two? Yeah, these are just ideas that you can take from money from the trust. I'm a big fan of private case management. I'm a big fan of family vacations.
I
I
think
think,
that the family vacations are a respite, and I'm also a big fan in your trust document, allowing to hire professionals. So, do you need a
yes,
CPA that's nuanced in special needs trust? Do you
yes,
need a financial advisor
yes,
that's nuanced in special needs? Do you need
yes.
an estate planning attorney? The answer is yes, yes, and yes. And the special needs trust should have provisions to be able to pay for those professional services. Being a trustee is not a small job, and somebody needs to have the financial wherewithal to do that and be in a person of trust. I have
Mm-hmm.
a trust fund client whose mother died and left significant assets, oil and gas, and like significant. Mom really, really planned, single mom, and then she died young. Her daughter was 18 years old when she died. And her mom's best friend was the trustee, and she was a bad actor, and a lot of
Mm-hmm.
those assets went away before my client was old enough to even know what was happening.
Mm,
And by the time she found out what was happening, that trustee had died, right?
mm,
So anyway, things
mm,
do happen, and choose wisely, and you may need to change. And there are professional
mm-hmm.
banks. We have opinions and suggestions of professional trustees. On that, they're not free. They do cost, and they're not going to lock in your price because you might die 40 years from now. Okay. But there are fees when you're working with professionals. There's definitely going to be fees for those things. So I think, the biggest thing, I know that we always run out of time, Christina. I know that we're, running out of time for today, but work with a
Sure.
professional, have a
Yeah.
consultation, talk to them, show them what legal documents you already have in place. Christina spends a lot of time reviewing other people's legal documents, and she may say, "Hey, I like all of this, and I don't think
Yeah.
there's any changes,"
Yeah.
or "I would amend the following." She's
Yeah.
not going to tell you every single time of I would ball this up and throw it in the trash and start over.
No.
And
No.
if there is a recommendation for that, there's going to be a definitive reason why behind that. Some person said in our area, some of the local ARCs have programs that have them acting as the trustee or other capacities when they're gone. I've seen or heard of that before. I've heard of some of the residential living places, being able to act as successor or guardian of the person. And so if you're looking at residential living
Yep.
options, you should ask specifically what their policies are on that. And I know Robert wasn't here with us today, but Robert Pierce at Christina's office, he's a care navigator. He's awesome. He really has helped families navigate and figure out where do we need to go, who's going to take a Medicaid waiver, who's private pay, who has the bed. Can my loved one stay there, live there, and die there, like age in place or things like that? And Robert Pierce is really, really, really good. But just having these conversations and knowing that even if you say, hey, it's me, there is nobody else, there are professional people out there that can help you with that. Because I know a lot of people feel, oh, I don't know what I just did on my slides. I lost my slides. So everybody today is going to get a copy of today's slides and a link to the recording, and we're going to include that educational power of attorney
Thank you.
to participants as well. There are entire presentations on ABLE, on guardianship, on any of the letter of intent you mentioned earlier. We've got entire presentations on that. I just want to look. I've got one person that said, how can a 28 and 29-year-old receive child support and not
Oh,
impact their SSI?
oh, yes. Okay. So yeah, I was going to make a little star for that. So if they're receiving child support, what you'll need to do is go back to the family law attorney, work with a special needs attorney like myself. We will do something that's called a SAPSR. And what the SAPSR stands for is a suit affecting parent-child relationship. We will ask for the court to direct the child support into a first-party supplemental needs trust. The other thing that we'll do is make sure that we're working with the Attorney General's office if the child support is going through the AG's office. So that was a great question. Thank you for bringing that up, Allison.
Okay, a couple of other ones. Everybody's going to have Christina's contact information, my contact information. There's going to be a link for the upcoming webinars and that you can register for as well. One person said that they've got 3 kids diagnosed with autism, 15, 12, and 12. They don't get any benefits right now. And that may be a one-off conversation. Largely, those SSI benefits are based off of the parent's income and assets prior to age 18.
Yeah.
So it's very dependent on that.
Yeah, I was just going to suggest to go to your local LIDA. I don't know if you know what your LIDA is, and make sure they're assessed and get your kiddos on the waiver programs. If you don't know what a waiver program is, go to Consolidated Planning's YouTube channel. They will show you how to get your kiddos on those waiver interest lists.
And I think that there's actually a webinar this week that Michelle is doing either tomorrow or Thursday on the Medicaid waivers. And that is going to be a very important component.
Yeah.
So I think we've answered the bulk of the questions today, and I know that we're out of time. Everybody submitted great questions. We usually run out of time before we get to all of them. But Christina, you always have great information. And I just want to encourage everybody. You guys are here. It's not about looking back about what you haven't done or what you're worried about. It's about looking forward and getting the right people on the bus in the right seats, and getting you moving in the direction that you want to go for your family, for your own retirement, for your loved one with a disability, and your neurotypical kids. You've got this. We've got you. Certainly, we look forward to meeting with you and learning more about your situation. Do check out the Chosen Clinic, their website, and who they serve, and just keep them in mind as you come across families. We always come across families like ourselves and other people that might be a good fit for certain things that we've come across. So no monopoly on good ideas. Share those good ideas for sure.
Absolutely.
Thank you, Antoinette. It's been a pleasure, and we'll look forward to connecting with everybody again soon.
I really appreciate it.
Yeah, thank you, everyone. Stay cool. Talk to you later. Bye-bye.
Bye now.